All right, greetings and welcome to Dorsey and Whitney's M&A Update webinar. I'd like to introduce Brian Burke, a partner in Dorsey's Mergers and Acquisition Group. Brian?
Thank you. Good afternoon, everyone, and welcome to the January 2024 edition of the M&A Update, our annual review of Delaware corporate and alternative entity law updates that every M&A practitioner needs to know. So my name is Brian Burke, and as always, I'm joined today by my partners Amelia R. Messa and Jonathan A. Van Horn. We have quite the packed presentation today for you with nearly 80 slides covering statutory updates, fiduciary duty, and post-closing damages litigation, squeeze outs, busted deal litigation, non-competes, independent accountants, and much, much more. But first, we start as we always do with the news from Delaware, and I turn it over to you, Amelia, to lead us off.
Thank you, Brian. So as a Delaware practitioner, one of the things that I am constantly asked is why Delaware? Why should we form our entities in Delaware? The first reason is the fact that we are all familiar with Delaware law. It's what we all learn in law school. It's what we're talking about today. The second reason is the sophistication of our judges and the quality of our courts. Unlike a lot of states where judges are selected by elections where people don't really know who they're voting for, in Delaware, the process is a little bit different, and our judges are picked first by a nominating committee with former judges and respected practitioners from town. So, as an example of our great judges, this year we have two new Supreme Court justices. This was due to the retirement of Justice Vaughn and the elevation of Justice Montgomery Reeves. So we have new Justice Abby LaGros and Justice Chris Griffith, and as you will see from the materials, they are both incredibly impressive. So we look forward to seeing what they do on our courts. So the third reason I give people for why Delaware are our state-of-the-art statutes. Unlike almost every state, Delaware statutes are amended every single year. Initial drafts of the amendments are done by practitioners in town based on things that we see happening and as reactions to case law. So this year was no different. We had a whole slew of amendments that went into effect on August 1st. So to get us going with the alternative entity amendments, first we amended 18209F, which is our merger section, to clarify that a duly approved merger can also affect an amendment to an LLC agreement or even adopt a brand new amended and restated LLC agreement for the surviving or resulting LLC. You cannot, however, adopt a new LLC agreement for the non-surviving entity, which makes sense. This was just a clarifying amendment, but it's good to look at because it's a reminder that if you're ever in a situation where you want to amend your LLC agreement, but you don't have the approval for it, if you can get the approval to do a merger, that's one workaround, which will allow you to amend anyways. We also had some amendments to our series provisions of our statute. So now in the same way where if you have an oops moment and you accidentally dissolve your entity, you can revoke that dissolution. You can now do that if you accidentally revoke termination of a protected series, or you dissolve a registered series on accident. We had some amendments to our division provisions as well. So if you remember, a couple of years ago, we added the concept of division to the Delaware entity statutes. Basically, it's the opposite of a merger. So you basically can take an LLC and divide it into two or more entities. Currently, to do this, you file a certificate of division. That certificate has to state the name and business address of a division contact, as well as the name and address of the division company where you're going to keep the plan of division. So it's foreseeable that some of this information may change over time. So our amendments this year provide that if at any time that information changes over 6 years following the division effective date, you have to file a certificate of amendment to update that information. Finally, we added a new 18506 to clarify that when you're doing a subscription for an interest in an LLC, that subscription agreement can be made irrevocable, so long as the subscription itself states that it is irrevocable. I know I was talking mainly about LLCs, but these amendments all apply to limited partnerships and general partnerships as well. Finally, we have a new Article 12 to our Delaware UCC. This is being adopted by a whole bunch of states right now. I don't know yet what New York is going to do. Article 12 was drafted by the Uniform Law Commission together with the American Law Institute. Delaware did adopt the uniform version of this. Article 12 basically provides updated rules for commercial transactions that involve all of those new emerging technologies, virtual currencies, blockchain stuff, things that I admit to not fully understanding. Basically, it creates a new definition of controllable electronic records to address all of these digital assets. So with that, we'll pass it over to John to tell you about the GGCL amendments.
Hey, thanks, Amelia. So amendments to sections 152, 153, and 160B are all technical amendments that deal with treasury stock, that is, stock of a Delaware corporation that after issuance is either repurchased or redeemed by the corporation. The amendments to sections 152 and 153 clarify that treasury stock may be issued for consideration for value less than, equal to, or in excess of par value, and that the consideration may consist of any combination of cash, tangible or intangible property, or any benefit to the corporation. Conforming changes were made to section 160B, which permits a corporation to resell treasury shares that it has acquired either through repurchase or redemption, unless they have been previously retired or are required by the corporation's charter to be retired upon repurchase or redemption. The amendments to section 157C continue a project that we started a couple years ago, which expanded the ability of a board to delegate its authority to issue stock or stock options in the corporation. The 2023 amendments address some process points around delegated authority to issue stock options and require that when delegating its authority to issue options, the board or the committee must set certain timing parameters, both with respect to when the options themselves can be issued and with respect to when the stock underlying the options may be issued. The amendment eliminates a requirement that the delegation limit the number of options to be issued, but retains the requirement that the delegation limit the number of shares issuable upon exercise of the options issued pursuant to the delegation of authority. In 2013, Delaware adopted sections 204 and 205. These sections allow a corporation to take statutory action to remedy defective corporate acts. Defective corporate acts include acts that do not comply with the requirements of the statute, the DGCL, or the corporation's charter or bylaws. Section 204 provides a self-help ratification remedy. Section 205 provides a judicial validation remedy. Based on experience with a more commonly employed self-help remedy, Delaware amended Section 204C to adjust the process for determining the stockholders entitled to vote on a ratification matter that is submitted to the stockholders for a vote. The amendments also eliminate the requirement to file certificates of validation with the Secretary of State's office in certain circumstances, and then in circumstances where the certificate is required to be filed, they've streamlined the contents of the certificate. The amendments to Section 228E deal with the determination of a record date for required notice to non-consenting stockholders of actions taken by written consent in lieu of a meeting. Prior to this amendment, it was possible that the record date for notice could differ from the record date for the written action itself. As amended, Section 228E now provides that the record date for right to receive notice is the same as the record date established for the written consent itself under Section 213B of the DGCL. The amendments to Section 242 address some problems commonly encountered by public companies whose stocks have become so-called meme stocks or are otherwise predominantly held by retail stockholders. These are situations that present challenges in getting sufficient stockholder engagement in situations where votes on certain types of charter amendments are required. First, Section 242D1 was amended to provide that a forward stock split, for example, a 5-for-1 or a 10-for-1 split, can be affected without any stockholder vote if the corporation has only a single class of capital stock that is not divided into separate series. In the context of a single class, single series capital structure, a forward split does not present dilution risk to any group of stockholders, so no stockholder ratification necessary. The Second Amendment changes the stockholder approval requirements for a reverse stock split. Examples here, a 1-for-5 split or a 1-for-10 split. These are the sorts of reverse splits that are commonly affected by companies to comply with minimum stock price requirements under exchange listing standards. As amended, a reverse split affected under Section 242D2 now requires only a majority of the votes cast, as opposed to the old standard of a majority of outstanding shares. The lower voting threshold only applies as long as the shares are listed on a national securities exchange and the corporation meets listing requirements related to the minimum number of holders post reverse split, that is, after the reverse split. Finally, several provisions of the DGCL related to conversions and domestications were amended. An amendment to Section 390B lowers the default vote required to effect a transfer, domestication, or continuance from all outstanding shares to a majority of the voting power of outstanding shares. Subject to certain exceptions, including the market out exception, Section 262, that's Delaware's appraisal remedy, was amended to provide for appraisal rights in connection with a transfer, domestication, or continuance affected under Section 390. Last, and quite possibly least, Section 266 was amended to allow corporations to adopt plans of conversion or domestication similar to a plan of merger, which established the terms of the conversions or domestications, including the treatment of any equity securities of the converted or domesticated entity. So that's it for the 2023 DGCL updates. Now let's hear from Brian on some updates on Revlon.
Thank you, John. Yeah, moving over now to updates from the Delaware courts. We start with a new case applying Revlon enhanced scrutiny to award post-closing damages to plaintiff stockholders. Now, it's been a couple years since we've had occasion to visit the world of Revlon, so let's first take a step back in time to see where we were at. In 1986, the Delaware Supreme Court issued the landmark Revlon ruling, which found that when a board pursued a sale of the company, an enhanced scrutiny standard of review applies. The question posed to fiduciaries is whether they have exercised their powers in the service of a specific objective, maximizing the sale price of the company for the benefit of the stockholders. But we later learned if the merger is not subject to entire fairness standard due to a controlling stockholder, then the irrebuttable business judgment rule standard of review applies in post-merger damages claims where there has been fully informed, uncoerced approval by a majority of the disinterested stockholders. That's the Corwin case, and it should be said is the doctrine that was first previewed just over 10 years ago by Vice Chancellor Laster, right here in Minnesota at the Dorsey and Whitney Foundation lecture, which remarks were later turned into an important law review article. Have to say that. Well, when Corwin applies, waste must be shown to overturn the irrebuttable business judgment rule, and therefore dismissal on the pleadings is typically the result. Now, if Corwin doesn't apply, if, for example, the stockholder vote was not fully informed, directors and now officers may have the benefit of a 102b7 exculpation provision, which exculpates directors and officers for monetary damages for a breach of the duty of care. Corwin has had a huge impact to date, and we have seen and discussed here at the M&A update countless Revlon-type post-transaction damages claims that have been summarily dismissed on the pleadings, which has led to a question: is Revlon now more a source of board guidance than a liability rule? But we have seen instances where Corwin doesn't apply to shift the standard of review, and there are still sources of potential liability. First, officers may still be liable for breaches of the duty of care if the corporation hasn't updated its 102b7 exculpation shield. And of course, duty of loyalty breaches by both officers and directors are still on the table. Second, we have seen that advisors, and in particular bankers, may still be liable for aiding and abetting breaches. 102b7 shields do not eliminate the underlying breach. They only eliminate liability for monetary damages. So the underlying breach can still serve as a predicate for aiding and abetting liability, as the bankers in the rural metro case unfortunately found out the hard way. Well, that brings us to last year's Mindbody post-trial decision, where we saw another source of potential liability, in this case, the buyer. We've talked about this case before in some of the earlier stages, and it is one that Chancellor McCormick has called the paradigmatic Revlon claim. A conflicted fiduciary who is insufficiently checked by the board and who tilts the sale process toward his own personal interests in ways inconsistent with maximizing stockholder value. It arose from the 2019 sale of Mindbody to Vista Equity Partners in a take-private transaction for $36.50 per share. Although Mindbody was a publicly traded company, it still had substantial involvement from its CEO and founder, who controlled 20% of the voting power and chaired the board of directors. At the end of 2018, the company completed a fast-moving sale process and ultimately was acquired by third-party Vista in a transaction that was approved by the stockholders. Well, the plaintiff stockholders in this case brought a variety of claims, with most dismissed or settled before trial, but 3 claims remained. First, that the CEO breached his fiduciary duties by tilting the sale process in favor of Vista. Second, that the CEO breached his fiduciary duties by failing to disclose the facts about how he ran the sale process in his discussions with Vista. And third, that Vista, the buyer, aided and abetted in the CEO's breach of his duty to disclose. The main thrust of these claims is that the CEO and founder fell in love with the idea of Vista as a buyer for his company. And so, with a little help from Vista, he pushed through a flawed sale process in their favor. The drive to sell the company in the first place was due to the CEO's own liquidity needs, but the drive to push toward a sale to Vista, at the exclusion of other buyers, happened after the CEO attended Vista's Founders Summit, where he thought their presentation, in particular the part about how much money founders can get when they partner with Vista, was mind-blowing. He therefore proceeded to take every step he could behind the board's back to tilt the sales process in Vista's favor. He had the CFO lower earnings guidance to depress the stock price and make it easier for Vista to present an attractive bid. He gave Vista thousands of documents in diligence while other bidders received less than 40. And he also disappeared on vacation for most of the go shop period to somewhere in Costa Rica without cell coverage, just to name a few of the actions that he took. Well, in her post-trial decision, Chancellor McCormick applied the Revlon Enhanced Standard of Review to plaintiffs' claims. She found that Corbin was not applicable here to shift the standard of review because the stockholder vote was not fully informed about all of the CEO's activities and discussions with the buyer. And furthermore, this happened before there was a 102b7 exculpation shield in place for the officers. With respect to the first claim at issue, she found that the CEO breached his fiduciary duties by tilting the sale process in favor of Vista. This was the classic Revlon claim. The CEO did not maximize the sale value. In fact, his tips and side conversations with Vista helped Vista acquire the company at a lower price. Similarly, for the second claim, she found that the CEO breached his fiduciary duty of disclosure by not disclosing many of his side conversations with the buyer to the board or the shareholders. And on that note, she found that Vista, the buyer, aided and abetted the CEO in that breach because it knew of those conversations and because it received drafts of the proxy materials and was contractually obligated to review the proxy materials and inform the company of any material omissions. Therefore, the court found that Vista knowingly participated in the breach. As a result, the CEO and Vista were both found to be jointly and severally liable. Now, while the court found that the damages available to plaintiffs here were only nominal damages, as opposed to quasi-appraisal damages that were requested by the plaintiffs, evidence still supported that Vista was prepared to pay $1 more per share. In fact, the deal team thought that they would pay $1 more per share. And so Chancellor McCormick awarded plaintiffs that dollar plus interest, resulting in a judgment against the CEO and Vista for $44 million. So the takeaway here is that Revlon can still be a source of potential post-closing damages liability, particularly for buyers and advisors who may be found aiding and abetting an underlying fiduciary duty breach. With that, John, I'll turn it over to you for an update on another case we haven't talked about in a while.
Yeah, thanks, Brian. You're right. We haven't talked about Con Ed in a while, but in the last several editions of M&A Update, we have covered various lawsuits filed in connection with Elon Musk's acquisition of Twitter, which is now known as X. That deal, it seems, is the gift that keeps on giving, at least for content creators like us, although the lenders and co-investors in that deal may have a contrary view. The recent resolution of a lawsuit filed in connection with the Twitter acquisition has sparked a renewed conversation among deal practitioners about the enforceability of so-called Con Ed provisions. Con Ed provisions take their name from a 2005 decision of the Second Circuit, Consolidated Edison versus Northeast Utilities. The objective of Con Ed provisions is to establish a right of recovery for lost premium damages against the buyer in the event of a broken deal. In cases where the proposed deal price represents a significant premium to prevailing market prices, the damages represented by the lost opportunity for the target stockholders to realize the deal premium may far exceed the target company's actual direct damages. For example, in the failed Con Ed deal itself, the direct damages incurred by Northeast Utilities were less than $30 million. In contrast, the merger premium lost by NU stockholders was over $1 billion. In the Con Ed decision, the Second Circuit, applying New York law, held that NU stockholders could not recover the lost premium from Con Ed because, one, the lost premium damage was suffered by stockholders, not NU itself, and two, the merger agreement contained a no third-party beneficiaries provision. Following the Con Ed decision, fearing a shift of incentive structures that would have the effect of turning definitive merger agreements into buyer options, three principal approaches developed in an attempt to provide for recovery of lost premium damages in the event of a terminated deal. The most direct approach is to explicitly provide in the merger agreement that the target stockholders are intended third-party beneficiaries. The problem with this approach, particularly from buyers' perspective, is that it opens the Pandora's box of multi-jurisdictional, multi-party litigation brought by stockholders, essentially a food fight. The target, too, has concerns about a food fight because of the resulting loss of control of litigation and the ability of the target's board to tailor the litigation to its strategic objectives. Though employed in some public company merger agreements, this is a minority approach. Under a second approach, the stockholders are made express third-party beneficiaries, but language is included in the contract that purports to designate the target company as the exclusive agent for its stockholders in pursuing damages against the buyer in the event that the deal breaks. The third approach includes defining lost premium damages as among the damages that the target can recover from buyer, essentially trying to bring them into the same realm as the target's direct damages. Now, let's bring this back to Elon Musk. You'll recall that after signing a definitive agreement to acquire Twitter in April of 2022, Elon got cold feet and unsuccessfully attempted in July to terminate the merger agreement. Twitter sued in Delaware Chancery Court to enforce the deal, and on the eve of an expedited trial, Elon changed course and proceeded to close the transaction in late October. In late July, a Twitter stockholder named Luigi Crispo sued Elon and his affiliates in Delaware, seeking specific performance of the merger agreement and damages. Prior to the closing, most of the elements of Crispo's complaint were dismissed, but one claim that the damages provision of the merger agreement conveyed third-party beneficiary status to stockholders seeking damage for breach of the merger agreement survived the dismissal. Once the deal closed, however, Crispo elected not to submit briefing on the surviving claim, and the lawsuit was presumed dead. However, following the closing, Crispo petitioned the court for a mootness fee based on an argument that his lawsuit had played a role in forcing Musk back to the table and proceeding to closing. To prevail in a mootness claim, one of the elements the plaintiff must demonstrate is that the original suit was meritorious when filed. It's in this context that Chancellor McCormick took the opportunity to evaluate the three Con Ed approaches I described earlier under Delaware law. After first taking a deep dive into the law governing third-party beneficiary status and unique Delaware considerations arising in the stockholder context, the Chancellor examined the lost premium damages provisions commonly included in merger agreements after Con Ed and addressed whether the lost premium provision in the Twitter merger agreement granted stockholders status as third-party beneficiaries to seek damages for lost premium. Noting the general reluctance among deal practitioners to make stockholders express third-party beneficiaries of merger agreements, the Chancellor addressed the agency approach that I described, characterizing it as on shaky ground. The Chancellor noted that there is no legal basis for allowing a contract party to unilaterally and irrevocably appoint itself as an agent for a non-party. So it sounds like that's a non-starter. The Chancellor did, however, offer one possible solution to this problem, and we'll get back to that in just a second. Chancellor McCormick then turned to an analysis of the Twitter merger agreement provisions. She focused first on the contract's lost premium provision, which states that in the event of the breach of the merger agreement, buyer would be liable for the benefits of the transaction contemplated by the agreement, lost by the company's stockholders, taking into account the lost stockholder premium. So a very seller-friendly standard. The Chancellor concluded that since the target, though, has no right or expectation to receive merger consideration, including the deal premium, the target itself has no right to directly enforce the lost premium provision, and that the lost premium provision is only operative if the merger agreement confers third-party beneficiary status to stockholders. The Chancellor then tackled the agreement's no third-party beneficiaries provision, which were comprised of a broad disclaimer of any third-party beneficiaries subject to three specific carve-outs, none of which were relevant to the arguments here. Employing a cardinal rule of contractual construction that seeks to give effect to all contract provisions, the Chancellor reconciled the seemingly contradictory lost premium provision with a no third-party beneficiaries provision to conclude that among the possible reasonable readings of the merger agreement is a reading that it did confer third-party beneficiary status to seek lost premium damages to stockholders, but not while the target was pursuing specific performance. The specific performance remedy was reserved for the target itself. So while CRISPO is not a direct holding on the enforceability of Con Ed provisions in Delaware, it can be fairly read as essentially closing off some avenues of enforcement while leaving open a possible path. Now, back to that footnote. In her analysis, the Chancellor posed the question of whether the flaws in the agency theory could possibly be remedied by a charter amendment that designates the corporation as agent for the stockholders for the specific purpose of collecting lost premium. And we've heard some rumblings of a possible DGCL amendment that would be intended to facilitate a charter-based solution to Con Ed. So we'll stay tuned to see if this approach gets any traction in the coming months. And in the meantime, I'll send it back over to Amelia for some fresh squeezed news on squeeze-out mergers.
All right, thanks, John. So we have the Cygnus case. This case really covers kind of a little bit of everything, so it's an interesting one. As background, we have an LLC. However, it originally actually started out as an Indiana corporation. It then went bankrupt, and in the restructuring process, it became an LLC. So our plaintiffs here, they're minority members of the LLC, but they didn't start out that way. They started out as stockholders of the corporation. In this case, we have Strategic Value Partners, SVP. They're kind of our bad actor in the case. They're the majority member. This LLC is set up to look like a corporation. So it has a board with 5 members and 2 independent managers. This means that some of the corporate case law precedent will most likely apply. Our LLC agreement here also notably had a bunch of restrictions and consent rights aimed at preventing SVP from acquiring additional interest in the company. which is exactly what they then went on to do. So SVP launches a tender offer where it did increase its ownership stake in the company. They provided no disclosures whatsoever to our minority members. After that, they set in motion their squeeze-out merger. In this case, they did provide some disclosures. However, it was very minimal. They set up what they called to be a special committee with one independent manager who approved it. However, the independent manager was not really that independent. They claimed to have received a fairness opinion. However, even when they were asked to provide it at trial, they were unable to. Our plaintiffs here tried to ask for information about the transaction, and they were either ignored or turned down. So they brought suit. The first thing they challenged was the breach of fiduciary duties of our board and SVP. Now, the one difference between LLCs and corporations here is that with LLCs, in your LLC agreement, you can modify or eliminate fiduciary duties. And that's exactly what they did here. And the court finds that the elimination of the board and SVP's duties was plain and unambiguous, and therefore it applied. Interestingly, though, our agreement here did not waive those duties for officers. So the court finds that to the extent directors have duties, those same duties may apply to our officers here, just like it would with a corporation. So the first duty the court looks at is the duty of disclosure. The court talks about the duty of disclosure as being not its own separate duty, but a contextual manifestation of the duties of care and loyalty. So it really depends on the facts involved in the situation. And the court finds that here, the duty of disclosure would arise in this type of tender offer context. It requires that directors and thus officers must disclose all information which is going to be material to the vote of the shareholders or here members. So because directors would owe a duty of disclosure in this type of transaction, so do our officers here. The officers, therefore, had a duty to speak up about the severely underpriced tender offer. And since they didn't do that, they potentially breached this duty. The officers tried to argue that, no, we were just following what the board said, and we were just following our duty of obedience. And the court said, yes, there is a duty of obedience. However, that duty does not apply if listening to the directors would cause you to breach a fiduciary duty, which is what was happening here. So next, we looked at whether the duty of disclosure would also apply with respect to the squeeze-out merger, and the court found that yes, in fact, it would. Once our officers here chose to speak up because they did provide that kind of minimal level of disclosures, they had a duty to comply fully with the duty of disclosure. Here, the disclosures that they provided contained absolutely no reasoning, no discussion of how they got to the price or the negotiations involved, and therefore they did not provide all the material information that they were required to provide. There was also a challenge with respect to the protective provisions in the LLC agreement, and the court found that yes, in fact, SVP had not gotten the proper consent rights, so we have a potential breach of the LLC agreement as well. And then the final challenge is with respect to the breach of the implied contractual covenant of good faith and fair dealing. So the court does the thing it always does with these claims. It goes through the whole background about how it's only going to apply this sparingly. It's such an extreme remedy for the court to basically rewrite an LLC agreement, so it doesn't want to use it if it doesn't have to. Here, the court goes further, though, and talks about that in the alternative entity context, especially where parties have agreed to eliminate fiduciary duties. The court has a lot less sympathy for these parties and is less likely to use the implied contractual covenant because basically you negotiated this deal and got into this situation yourself, is their view. However, this case was a little bit different because if you remember back, our minority members here did not want to be members of an LLC. They hadn't put themselves into this LLC agreement. They were forced into it. They started as stockholders of a corporation where they had those protections that they no longer had here. So here, this is a court of equity, and the court feels bad for them. So it does go down the road of looking at the implied contractual covenant. In looking at the doctrine, it requires there to be a gap in the contract that the court finds to be appropriate to fill. So if the parties, in fact, negotiated a term and decided not to include it, the court's not going to rewrite that contract and put it back in. Here, the court finds there are potential breaches with respect to the disclosures that were made, both in the tender offer and the squeeze-out merger. This was based on Supreme Court precedent that the implied covenant can obligate defendants to provide both truthful and accurate disclosures of all material information. The court also finds that the implied covenant could apply with respect to claims that the one independent manager was not actually independent, finding that the approvals for the transaction were not obtained in good faith or with fair dealing. So with that, I will pass it over to Brian to talk about some busted deal case law.
Thank you very much, Amelia. Yeah, we have two really interesting cases last year that arose out of busted deals. And both of them held important drafting lessons surrounding when and how buyers can terminate deals and walk away. So the first such case was H Control Holdings versus Anton Infrastructure. And the background of the dispute here is that in early 2022, Optical Tel, which was a portfolio of broadband companies owned by a one Mario Bustamante, launched an auction sale process reaching out to more than 50 potential bidders. By November of that year, Anton Infrastructure emerged as the winner of the auction with economic terms that they offered, providing a $230 million base purchase price and up to a $30 million earnout. So the parties promptly entered into a period of exclusivity and began negotiating the transaction documents, using as a starting point seller's auction draft stock purchase agreement. In parallel, buyer continued to do due diligence during this exclusivity period. However, interestingly, every time they asked for a capitalization table, sellers would send them one that was slightly different, which naturally raised buyers' concerns about the accuracy of the capitalization tables that they were being given. By December, the parties had negotiated this time a merger agreement, and Anton agreed to acquire Optical Tel. So the diligence concerns the buyer had around capitalization were reflected in four key points that they negotiated and included in the final purchase agreement. First, buyer expanded the capitalization representation to cover excluded securities of the acquired companies, broadly defined. And importantly, buyer left the representation unqualified as to materiality and left in seller's language, expanding it to cover phantom equity as well. Second, buyers struck a de minimis qualifier in seller's draft bring down closing condition for fundamental representations, thus making it a flat bring down. So fundamental representations, which included the capitalization representation, had to be true and correct in all respects at closing. Third, buyer revised the structure to be a merger instead of a stock purchase. This would reduce claims for any missing shareholders that they forgot about to be one for money damages rather than ownership claim in the new entity, as all shareholders would be cashed out at closing. And fourth, to kind of backstop that, buyer added a $1 special indemnity covering any capitalization issues backed by Mario Bustamante himself. With these changes, buyer's investment committee was comfortable with the deal and approved the transaction. Well, after the deal was announced, a former employee, Rafael Marquez, saw the announcement in the papers and came forward claiming that he had an ownership stake in Optical Tel. And he had a software development agreement from a few years back with one of Optical Tel's subsidiaries that promised him a quote 5% ownership in that subsidiary to be distributed upon a liquidation event. Now, he argued that this meant 5% of the whole business, so he was owed over $5 million instead of just $200,000 or 5% of that subsidiary. And he refused all reasonable settlement overtures by the sellers here, instead taking it upon himself to have him and his counsel call everyone he could on the deal and demand a full payout. Against this backdrop, a second former employee also came forward claiming a 5% ownership, although this time without evidence supporting their claim. To try and resolve the issue with Marquez, seller proposed a restructuring plan to buyer where it would assign all the IP out of the subsidiary in question to a different Optical Tel entity and would then dissolve the subsidiary and keep it out of the transaction, with Mario Bustamante indemnifying for any remaining issues. When asked to approve this under the interim operating covenants, buyer said no, but seller went ahead and did it anyway and filed a certificate of dissolution in Florida for that subsidiary. Well, buyer became increasingly frustrated that these issues weren't being resolved and eventually served notice of breach on each of the above issues and moved to terminate the deal. Chancellor McCormick agreed and said the buyer properly terminated the deal under the contract. Marquez arguably held phantom equity in an entity, so the flat bring down of the capitalization representation was not met, and she seemed to question the rationale for a buyer terminating a $200 million deal over an issue that was likely only $200,000 to $300,000, but said ultimately it is not for this court to question the business wisdom of buyer's decision to terminate. Buyers negotiated for the ability to terminate if the capitalization representations were not accurate in all respects, and this decision enforces that right. Over over to you, John.
Yeah, thanks, Brian. So the next case involves a failed acquisition of an electric scooter vendor called Rebby Inc., founded by tech entrepreneur Pep Gomez. This must be the segment where we have flamboyant founder names. In 2021, a PE-backed venture called House of Lithium, or HOLE, invested a total of $5.8 million in Rebby and acquired an equity stake of approximately 17%. The parties quickly moved into negotiations for a transaction in which HOLE would acquire the rest of Rebby and sign the first of a series of term sheets in December of 2021. In the background, HOLE was making plans to become public through a reverse takeover with a Canadian public shell. By the time a second term sheet was executed in January of 2022, HOLE had announced its reverse takeover plans. The second term sheet required HOLE to pay a break fee of $2 million if the deal was not completed by March 15th and had attached to it a form of purchase agreement to be entered into by the parties. The opinion goes on to describe a fast-paced diligence and negotiation process during which a third term sheet was executed. The third term sheet had a new term that Rebby deliver interim unaudited financial statements for the 2021 operating year. This new term appears to have derived from a troubling finding from due diligence. Rebby did not have audited financial statements. In fact, it might not have had financial statements at all. Now remember, that's a problem for HOLE given its aspirations to become a public company. In addition, HOLE learned that Rebby had never filed U.S. federal income tax returns. So, I guess you could call those red flags. In addition, 5 days before the purchase agreement was signed, there was a CEO change at HOLE's PE sponsor. Ready or not, the purchase agreement was signed on April 30th. One of the issues at trial was whether HOLE's execution of the purchase agreement was made in reliance on a promise by PEP not to enforce sellers' rights under the agreement, given the apparent open nature of some key deal points. Ultimately, the court finds that PEP's versions of events are more credible, and his story is that he merely offered assurances to work through any issues prior to closing. The deal continued to struggle during the period after public announcement of the entry into the purchase agreement, with Rebby's lack of audited financial statements posing an obstacle to securing funding, among other matters. In late May, HOLE sent a letter alleging various breaches of the purchase agreement and stating that it would not close until the breaches had been corrected. Around this time, the court concluded that HOLE had developed buyer's remorse, and eventually it decided it no longer wanted to complete the transaction. In August, the sellers sued HOLE for breach of contract in a 3-day December trial in front of Vice Chancellor Fioravanti ensued. After concluding that the purchase agreement was an enforceable contract, the Vice Chancellor focused on whether or not the closing conditions set forth in the contract had been satisfied, such that HOLE was required to close and complete the deal. Among the conditions to HOLE's obligation to close was a condition that each of the reps and warranties of the sellers in the company shall be true and correct as of the closing. So this will sound familiar to the case Brian described. A flat bring down, not qualified by any materiality standard. The court then analyzed several specific representations, including the capitalization rep, the financial statements rep, the compliance with law rep, and the no undisclosed liabilities rep, finding inaccuracies in both the capitalization rep and the financial statements rep. Noting both the unqualified nature of the bring down and the abilities of the parties to have contracted for a different result through the use of materiality qualifiers, if that is what they had wanted to do, the Vice Chancellor concluded that the bring down condition had not been satisfied and that HOLE was not required to close. The Vice Chancellor also took this opportunity to address an issue we've covered at length in previous M&A updates, sandbagging. Now, for reasons I don't really understand, sellers cited the 2022 Arwood case as supporting its position that Hull should not be able to rely on breaches of representations that it knew at signing were false for the purposes of not closing the deal. But as we reported in July of 2022, Arwood was used as a vessel to clarify the state of Delaware law of sandbagging after a footnote in a 2018 Supreme Court case had created some doubt about the issue. Vice Chancellor Fioravanti efficiently disposed of sellers' sandbagging claims in 8 tidy words. Delaware is or should be a pro-sandbagging jurisdiction. Case closed. Now, for a look at another perennial M&A update topic, Brian, it's back to you for non-competes.
Thank you, John. Yes, we saw 4 new non-compete cases since we last spoke to you in January of last year, with each challenging the formerly prevailing view that Delaware is a favorable jurisdiction in which to enforce them. When we last spoke in January of 2023, we talked about 2 cases from Vice Chancellor Zurn where the court both declined to enforce what it viewed as an overly broad non-compete, one in the sale of business context, that's Kodiak Building Partners versus Adams, and one in the limited partnership context, that's Ainsley versus Cantor Fitzgerald. Importantly, in each case, the conduct by the individual subject to the non-compete seemed likely to have fit within what the court indicated would have been an enforceable non-compete. But in each case, the court declined to blue pencil what it viewed as an overly broad and unenforceable non-compete. So in the first case we saw this year, on the Centurion case, Vice Chancellor Will, joined in the fun and took the same approach to a third type of non-compete, a non-compete incident to employment, which she found to be overly broad in scope and geography, with a nationwide and even international reach, and therefore it was unenforceable. And again, the court declined to blue pencil it. In the Hightower case, Vice Chancellor will address the sale of business and LLC agreement non-compete, both of which purport to be governed by Delaware law. Even so, she found that because they would apply against a financial advisor working in Alabama, the court must defer to Alabama's strong public policy against covenants not to compete, and therefore denied the preliminary injunction on those grounds. That leads us to the third case of the year, Intertech Testing Services versus Eastman. This case also addressed the sale of business non-compete, where a founder who sold his business gave buyer a 5-year worldwide non-compete covering just the seller's business. 3 years later, however, the founder went to work for his son at a company that self-advertised as, quote, being crafted from the ground up using the know-how and experience of the founders of Alchemy, the company he had previously sold. Vice Chancellor Will, however, again said that this non-compete was unenforceable. Quite simply, it was too broad geographically. Although it only covered the business of the sold company, it did so on a worldwide basis, which far exceeded the markets in which the sold company participate. Therefore, it was unenforceable, and again, the court declined to blue pencil it. Amelia, I'll turn it over to you for the 4th non-compete case that we saw this year.
All right, thank you. So our last non-compete case here is Sunder Energy. This one is actually interesting, not just because of the non-compete provisions, but kind of the background of how they came up. Here we have Sunder Energy. They sell solar power systems, and one of their sales guys, Tyler Jackson, left to go work with a competitor. Jackson was subject to restrictive covenants in this LLC agreement because he held interests in the LLC that were known as incentive units. The interesting thing here is that when this LLC was originally formed, the founders and employees didn't actually enter into a written LLC agreement, and they operated under an oral agreement, which I would advise people to never, ever do. But they all had a common understanding of what their deal was. Then our founders used company attorneys to put together a written agreement. They then went and sent that written agreement to the employees while they were all at a New Year's Eve party and assured them this is, consistent with what we've all been operating under, and it's really imperative that you sign it immediately. So the employees, trusting their founders, did just that, and they signed the agreement. In reality here, our LLC agreement actually was set up to benefit only the founders. It eliminated their fiduciary duties, took out the voting rights of those holding incentive units, and put in motion all of our restrictive covenants. Here, the restrictive covenants are just like those other cases that Brian was describing. They're really extensive, incredibly broad. They're so broad that with respect to Jackson, they would have applied to his wife and his children. The bad thing for Jackson, too, he held the incentive units and he had no way of getting rid of them. He was not allowed to sell them or transfer them. The company could repurchase them because Jackson had left, but of course they would repurchase them for no compensation. But the company had an option to purchase, they didn't have to, which meant that those restrictive covenants could last for forever. So here the challenge starts with a challenge to the enforceability, not of the covenants, but up to the LLC agreement. Here the court finds that our founders breached their duty of disclosure when they reached out to everybody at the New Year's Eve party and told them to sign. They had not disclosed all of the material facts that were necessary for our employees to sign, and they'd also made misleading and partial disclosures. So since the LLC agreement here was never validly approved, the court finds that the restrictive covenants are not actually enforceable. The court did look at whether, if the LLC agreement had been enforceable, would the covenants here have been enforced? And the answer was no. They were so overbroad that they wouldn't have allowed Jackson's daughter to even sell Girl Scout cookies. So that's how egregious these were. The fact that the term was indefinite because Jackson couldn't get rid of his incentive units was also unreasonable. And like the cases that Brian described, there was no legitimate business interest that could justify the covenants. But perhaps the most interesting thing in this case was the fact that Vice Chancellor Laster here spent pages of his decision giving his views on restrictive covenants, and the fact that so many of them are being used now in Delaware LLC agreements, really to avoid having to apply the laws of other jurisdictions where these types of covenants are unenforceable as violating public policy. He says that it's incredibly problematic for our Delaware courts to be addressing these non-compete provisions. He says Delaware should not be overriding the laws of other states on issues of great importance to them, especially if Delaware wants other states to respect its laws. He finally says that this is unsustainable in Delaware. Our courts are already too full. We don't have time to deal with all of these new restrictive covenants being put into operating agreements, noting that as of 2024, we now have over 2 million entities in Delaware. So he basically pleads for a legislative solution. And I'm not sure if he's going to get one, but he might get some help from the STC. They're all set up to vote in April on a final version of a proposed rule that was proposed last January that would ban employment non-competes. Notably, it contains an exception for people that are selling a business entity or disposing of all of the person's ownership interest in the business entity. However, that only is when a person holds more than a quarter of the business.
Okay, independent accountants, experts, or arbitrators. We turn to a case here looking into independent accountants and what they actually are. So first, what is an independent accountant? Well, purchase agreements commonly provide for independent accountants to resolve disputes over post-closing purchase price adjustment calculations. They're asked to resolve disputes about the final calculations of cash, indebtedness, transaction expenses, net working capital, and potentially even earnout metrics. Now, often the purchase agreement sets forth certain guidelines for the engagement and states that the independent accountant will act as an expert, not an arbitrator, or sometimes they will act as an arbitrator and not an expert. But what does that distinction mean? Well, that takes us to Vice Chancellor Laster's decision in Archkey Intermediate Holdings versus Mona. The dispute here arose after the founder of Mona Electronics sold his company to Archkey, a private equity-backed buyer, for $21 million. The purchase price at closing was estimated based on an estimated balance sheet, and post-closing, the buyer delivered an adjusted balance sheet under the purchase price adjustment mechanism for purposes of calculating the final purchase price. The agreement provided that any purchase price adjustment disputes were to be resolved by an independent accountant. Well, following the closing, buyer here did deliver an adjusted balance sheet, and their version of it showed that the purchase price should only be $8.4 million, meaning that the seller had to repay almost 2/3 of the closing proceeds that he was originally paid. The founder naturally brought suit and alleged a variety of claims, including that the buyer acted in bad faith. But Archkey responded here and said, hey, this is a purchase price adjustment dispute. Per the terms of the agreement, all claims around the purchase price calculations are for the independent accountant to resolve, not the Chancery Court. The purchase agreement here stated that the independent accountant shall act as an arbitrator, not an expert in resolving the purchase price adjustment claims. But even so, Vice Chancellor Laster said that this is in fact an accountant true-up mechanism, a term he coined in this decision, which falls somewhere on the spectrum between an expert determination and an arbitration. Even though the accountant was labeled an arbitrator, an accountant true-up mechanism does not involve arbitration under the FAA. It calls for an expert determination, albeit a slightly beefed up one. So then, what is the role of the court and what is the role of the accountant in the dispute? Well, Vice Chancellor Laster looked at who determines whether an accounting method complies with past practice. He said that's for the accountant to determine. He looked at who decides whether the agreement provides the gap overrides past practice. He said that's a contract interpretation question. That's for the court to determine. He then looked at whether who decides whether the buyer prepared the post-closing adjustments in good faith. And interestingly, he said that one was for the accountant to determine. He then looked at who determines whether the accounts receivable are uncollected. He said that falls squarely within the expertise domain of the accountant. That's for the accountant to determine. And lastly, he looked at whether there's a violation of the implied covenant of good faith and fair dealing. And he gave a two-part answer here, saying that the accountant must evaluate the adjustments first, then the court decides if the implied covenant was breached. And the theme behind all of this is the court defers to the expert within their areas of expertise, but anything outside that and interpreting the contract and other contractual claims are for the court to determine. All right, Amelia, over to you for some updates on alternative entity case law.
Okay, so I had a couple of cases this time that dealt with the dissolution process for alternative entities. Notably, it is different than for corporations. For example, an LLC does not file a certificate of dissolution like you do for a corporation. So nobody's actually on notice when an LLC dissolves. There also isn't a 3-year statutory wind-up process for LLCs, the same way there is for corporations. So this is one reason we see some corporations actually convert into LLCs when they're ready to dissolve. That way it gets rid of that 3-year period, and that way the directors and officers can kind of go about their business. So since we're a little bit low on time, I'm going to go a little bit quickly through these. We had a judicial dissolution case. So members and managers of an LLC can go to the court and ask them to dissolve the entity when things have become incredibly frustrated. Historically, courts have not granted this remedy if the LLC has a broad purpose in its LLC agreement. But here we had an exception to that. Basically, we had a JV type of relationship where the parties had gotten so upset with each other, they were even bringing lawsuits against each other. The court here actually looked outside of the LLC agreement and at a separate JV agreement that did contain a purpose and found that that purpose was so frustrated that it actually did grant the remedy of judicial dissolution. So an exception to our historical rule. Finally, we had a case on certificates of cancellation. Basically, with an LLC, you dissolve, you then go through your whole wind-up process, and finally you file a certificate of cancellation, which ceases the existence of the LLC. In this case, there was an LLC that was a defendant in a bunch of tort litigation. And in order to get out of the litigation, the LLC just went and filed a certificate of cancellation to say, I no longer exist, so you can't sue me. Our petitioner here was asking the court to nullify that certificate of cancellation. And interestingly, Richards, Layton and Finger, a Delaware firm, represented the LLC. And the court said, this is impossible for RLF to actually represent what it called as a defunct LLC. They found it to be not only puzzling, but impossible. Because once you are canceled, you no longer exist, and therefore you cannot engage counsel. So the takeaway here is canceled actually means canceled. And also the receiver was appointed, and the court basically said, no, you cannot just cancel yourself to get out of litigation. So unfortunately, I think we're out of time. Brian has some great slides put together with some quick hitters. So I'll turn it to Brian for the final goodbyes.
That's right, folks. That's all the time we have for you today. On behalf of Amelia and John, we thank you for your time and look forward to seeing you at the next M&A update. Thank you.